You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 118, Patent Litigation at the International Trade Commission. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. In the last episode, I gave a little bit of a teaser. I said it would be my last episode about patent litigation, except for maybe an episode about patent litigation at the International Trade Commission. Well, here it is, and here we go. In the last several episodes, I talked about litigation at trial courts, and before that, I talked about litigation that could happen at the Patent Office using the Patent Trial and Appeal Board to try to invalidate someone else's patent. But guess what? There's another place to litigate your patent, and that's using the International Trade Commission, which is called the ITC. Technically, it's not a court. It's where administrative law judges conduct administrative hearings, but it acts a lot like a court. Now, why would you want to use the ITC instead of a regular court to litigate? And when I say regular court in this episode, I'm talking about a federal district court, which is usually where patent litigation happens. There are several reasons, but one reason is that the ITC is usually quicker than a regular court. And it's meant for stopping the import of infringing goods from getting into the United States at ports by Customs and Border Protection. Now, typically the length of a patent matter at the ITC is about 12 to 18 months, and that's compared to about 2 to 4 years in a regular court. Another advantage of the ITC is that it has broad jurisdiction. In regular courts, it can be a pain to try to subpoena someone from out of state or have anything to do with properties outside of the jurisdiction. The ITC has subpoena power nationwide, and it has jurisdiction on all goods imported into the U.S., and that's called in rem jurisdiction, if you want to get all legal and fancy about it. Another reason people like to use the ITC is that the default position in regular courts is that you usually don't get injunctive relief in a regular court. Injunctive relief is getting an order that stops someone from selling the goods. And lots of times that's exactly what you want. But nowadays, courts are more likely than not to not issue injunctive relief, but instead they issue monetary damages only. But here's the thing. The International Trade Commission can't issue monetary damages. All they could do is issue orders that stop infringing goods from entering the country, and that effectively stops all sales if someone's importing the goods. So if you really want to stop someone cold from selling goods, the ITC is useful. So why doesn't everyone use the ITC? A couple reasons. First, you don't get any monetary damages, as I mentioned before. So if you win, you don't get any money. But you do get an order so that Customs and Border Protection will stop infringing goods from entering the country. And you can get a cease and desist order for selling goods that are already in the country that have been imported. Another reason that you might not want to use it is that your goods, if your goods are only made in the United States, there's really nothing about your product that has anything to do with importation, then the International Trade Commission isn't very useful. Another reason is that it might not be the best for you is that in theory, the patent has to be relevant to a domestic industry, like a piece of technology in research and development. And most of the time, this is in a high-tech field. So your regular consumer good patent for let's say your new swing set or patent you got for your new hand puppet probably isn't going to be enough for the International Trade Commission to take up the case because it's just not relevant to a domestic industry. The hand puppet industry, I'm sorry to say that it's just not important enough for the International Trade Commission to get involved. You'll just have to go to a regular federal district court. Now, there's been a lot of criticism about the ITC and that people are abusing the system and using it instead of just going to a regular federal district court for infringement issues that are just between two U.S. companies. And that the case really has little to do with importing infringing goods. But some patent owners, a lot of people like to call them patent trolls. Maybe I'll do an episode on patent trolls in the future. I think I've discussed them a little bit before. They're still able to get their case into the ITC for technical reasons. I'm not going to go into the details on how people are abusing the system, but lots of people think it's a big issue that needs to be taken up by Congress. So let's say that you want to get your case into the ITC. You successfully get it allowed to be tried there. So now let's go to the trial at the ITC. The trial at the ITC is going to have a lot of similarities to a regular court, but some differences too. It's not conducted in front of a jury, but it's in front of an administrative law judge. Also, remember how I said that maybe about 2% of patent cases filed in district court actually go through to trial. For ITC cases, it's about 45%. A lot of cases that are related to electrical, IT technology, semiconductors, these are usually big companies with importing technology. So these companies have lots of resources, and they're just not likely to settle as maybe some other patent cases that are in the federal district court, which might be for small consumer goods, and these small companies just don't want to litigate in court. These big companies, they're prepared to do that. The process of what happens is going to be a little bit different than a district court. One is that in an ITC case, there might be an independent investigation done by someone from the court. And this doesn't happen in a regular district court where you have to conduct your own investigation. But lots of things are going to be similar with how a trial is done. There are going to be motions, discovery, hearings, and stuff like that. In the end, the judge is going to issue an initial determination, and that's going to be whether the infringing product violates Section 337 of the Tariff Act of 1930, and whether there's a domestic industry. If the judge finds that there's patent infringement and domestic industry, there are two kinds of remedies that I mentioned already. One is an exclusion order, and the other is a cease and desist order. An exclusion order is sent to U.S. Customs and Border Protection, and it says to block all infringing products at the port of entry. If you get a general exclusion order, that blocks every product that infringes from entry, regardless of the importer or manufacturer. If you get a limited exclusion order, that only blocks products from a specific manufacturer or importer. The other kind of order is a cease and desist order. Why isn't an exclusion order good enough? Well, let's say that the company that was importing all these infringing products knew that they were about to lose the case. So what they decided to do was ship 1 million products over just before they lost the case, so there really wouldn't be anything more to import, and there'd be nothing to stop at the ports of entry, because nothing new is coming from the ports of entry. In this case, an exclusion order doesn't do much good. The cease and desist order prevents a company from stockpiling all of the infringing goods in the United States and then selling their inventory. As I mentioned, the first thing a judge does is issue an initial determination. At this stage, you can see who the judge is planning on saying wins the case. If you see that you lost your case in the initial determination, you can petition the commission to review it. But if you lose that, the initial determination becomes a final determination by the International Trade Commission. Now, final, just like a final office action rejection from the patent office when you're trying to get your patent issue, doesn't really mean final. I talked all about that in previous episodes about getting a patent. Just means you have to go to a different stage of litigation. So what happens after a final determination? The International Trade Commission is a kind of a court. Technically it's not, but it acts like it. And I've told you, it's not like a district court. The court is actually not part of the judicial branch of government at all. You probably learned that we have 3 branches of government: executive, judicial, legislative, and that courts are part of the judicial branch. Now, usually that's true, but this is a special kind of court. And as I mentioned, it's not technically a court, which means it's not part of the judicial branch. It's an administrative agency, which is separate from all the other branches of government. And they provide trade expertise to the legislative and executive branches. So once a final determination is made at the International Trade Commission, it's actually the head of the executive branch that can make the final decision on exclusion from import. And who is the head of the executive branch? Anyone? Bueller? The president of the United States. In other kinds of cases, the president can't just step in and overrule a court, except for maybe pardons, but that's a very limited kind of exception. If you're using the International Trade Commission, the president reviews the exclusion order, and if the president doesn't act within 60 days to overrule the final decision by the ITC, then the determination is final. But again, remember, final doesn't actually mean final. It just means that you have to take it to the next level. You can appeal the International Trade Commission's decision to the Federal Circuit Court of Appeals, which is a judicial court, and then you can also appeal that, if you lose it, to the Supreme Court. But that's probably not going to happen because ITC cases that make it to the Supreme Court are just very rare. If you're just a solo inventor, not part of some big high-tech firm, the odds of you using the ITC are probably pretty low. But let's say you have a patent, you're discussing the possibilities of suing someone with your patent litigation attorney. It doesn't hurt to ask them if your case should also be filed with the ITC, or for that matter, with the Patent Trial and Appeal Board, because a single patent can be litigated in all 3 and all at the same time. The Patent Trial and Appeal Board is only going to be used if you want to invalidate a patent. No monetary damages, no exclusion orders, or anything like that. In district court, you can challenge the validity of a patent and get money damages and get injunctions, but the injunctions are harder to get. At the International Trade Commission, you can't get money damages, but you can stop the import and sales with a cease and desist order. And as I mentioned, you could do all 3 at the same time. It just depends what you want to do, and certain things may happen. If you try to do all three at the same time, some might be paused for a part of it in order to see how one court rules. And then, you just have to work with this with your attorney to see the best route, all different kinds of strategies. And that's the basics of how the International Trade Commission works. And how it can be beneficial to patent owners because of the speed that it acts in. And you can more easily stop infringing products at the border and get a cease and desist order for products already that have been imported into the United States. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamondpatentlaw.com. or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.